So let me first start with the quick disclaimer that these views are mine and not necessarily that of the Commission. I think you heard that already today from the CFPB folks. You get the picture. So here is a quick outline of what I'm going to be talking about today, give you a sense of where I'm going here. First, we're going to have a brief overview of the FTC's legal authority in this sphere. I'm then going to review some of our recent auto finance cases and law enforcement work. And then we'll wrap up by talking about what some of the FTC's priorities are in this area going forward. I always like to start with a discussion of what our mission is, just so everybody is clear on that. So our mission is to prevent business practices that are anti-competitive or deceptive or unfair to consumers, to enhance informed consumer choice and public understanding of the competitive process, and to accomplish this without unduly burdening legitimate business activity. And we take all three facets of that mission very seriously at the Federal Trade Commission. In fact, we have an entire Bureau of Economics dedicated to market research, and so we try to take the whole picture into account when we take our actions. In the auto financing area, we have we enforce a number of federal laws that are relevant here. So we recognize that auto financing is an increasingly important area for consumers. For most consumers, buying a car is probably the second biggest financial transaction that they're going to make. So some of the key statutes that we enforce here are Section 5 of the FTC Act. I'm going to speak a little bit more detail about that in a minute. The Truth in Lending Act and its implementing regulation, which we call Regulation Z. The Fair Debt Collection Practices Act, which again, that's my comfort zone. The Consumer Leasing Act and its implementing regulation, and also the Used Car Rule. The broadest one of all those is Section 5 of the FTC Act. The FTC Act prohibits unfair or deceptive acts or practices in or affecting commerce. So what does that mean specifically? Well, an act or practice is unfair if it causes or is likely to cause substantial injury, is not reasonably avoidable, and is not outweighed by benefits to consumers or competition. If any one of those three elements is missing, it's no longer unfairness. A deceptive act or practice is likely to mislead consumers, acting reasonably under the circumstances, and is material to the transaction. So I'm going to spend a lot of time over the next few slides going over specific cases and acts that the FTC has found unlawful over the course of the last several years. That may lead to the impression that this is complicated or hard to understand stuff. From our perspective, most of the behavior that we see that we take on in our enforcement actions could really be characterized under sort of the common sense test of, are you misleading your consumer? So that's really the bright line test there. But I'm going to give you some more specific examples of acts and practices over the last several years that the FTC has found unlawful. I know you guys just had a presentation from the Consumer Financial Protection Bureau, so I want to make sure that I'm clear about what our jurisdiction is vis-a-vis the CFPB in particular. So the FTC has broad jurisdiction over persons, partnerships, or corporations acting in interstate commerce, except for banks and a couple of other entities that are not as relevant here. Under the Dodd-Frank Act, which created the CFPB, the FTC has exclusive jurisdiction vis-a-vis the CFPB over many dealers, principally those predominantly engaged in sales or leases and servicing, or that routinely assign financing to third parties. We share jurisdiction with the CFPB over non-bank lenders and buy here, pay here auto dealers. We also have rulemaking authority now in the auto finance area that we did not have previously. shortly after the enactment of the Dodd-Frank Act, the Commission organized a series of motor vehicle roundtables to assess the issues and concerns of the various stakeholders in the automobile purchase, finance, and leasing transactions. Basically, we were going to be renewing our efforts in this area, and we didn't want to step in blindly. We wanted to hear from all kinds of stakeholders about what was happening in the marketplace. And so the purpose was to gather information on auto finance and leasing issues, consider possible initiatives, and such as areas for law enforcement or education or other appropriate measures. And so we held 3 different roundtables in Detroit, San Antonio, and DC in November in 2011. We tried to get a really wide cut of all the interested parties here. I'm not going to go through them now, but you get a sense of that from the slide here. And this has been an important component in formulating a comprehensive strategy to protect consumers in this area. So some of the topics that came up with some frequency during the roundtables were dealer markups on financing, spot delivery or so-called yo-yo financing, the availability of advertised discounts and rebates, and contract add-ons. If you would like some additional information on those auto roundtables, we still have that information available on our website. I'll leave this slide up here for just a second if anybody wants to write that down. Okay, so switching gears now a little bit. Let's talk about what some of the FTC's most recent enforcement actions have been in the auto finance sphere. I'm going to just give you a preview here, and then we'll hit each of these in a little bit more detail over the next several minutes. So the first is deceptive claims to pay off your trade-in. Here at the FTC, we call those negative equity cases. I'll explain that in a little bit. The second one is the failure to safeguard sensitive consumer information. This is a big deal for us at the FTC, identity protection, protection of consumer information. I'll give you an example a little bit later on of an entity that failed to safeguard that data. Third is deceptive motor vehicle loan modification claims. This was a bit of a variation on something that we've seen a lot in the housing context, but we saw some examples of unlawful behavior with regard to motor vehicle loans. The fourth is deceptive cost, discount, and rebate claims in advertising. Got a couple examples of that for you as well. Deceptive motor vehicle sales assistance claims. I suspect that one may be a little bit less relevant for you guys, but we'll go through that one really quick too. It's pretty simple. And the last one is violations of the FTC's used car rule, and I'll explain that in a little bit. So the negative equity cases. Those were 5 dealerships that we filed administrative complaints against in April and May of 2012, and I've got the case information here. What I should add right now is that on our website we keep information about all of our cases publicly available. So if you were to go to ftc.gov, for instance, and want to learn about what the FTC found was unlawful in the Key Hyundai of Manchester LLC case, you could just type that into the search box. You'll find our press release, you'll find our complaint against them, and you'll also find the order that they're under. And that'll give you a lot of guidance as to what was unlawful there and what the stakes were. The claims in the negative equity case, we found that they violated Section 5 of the FTC Act, the prohibition on deception. And the claims were that they were saying basically, we'll pay off your trade-in no matter what you owe, implying that the consumer will have no further obligation on that prior loan. When in fact, the dealer was rolling the negative equity into the new loan, or in one case, they even made the consumer pay the difference out of pocket. The FTC also alleged that the companies violated both the Truth in Lending Act and the Consumer Leasing Act. So it gets a little bit technical here, and I don't want to dwell or bog down too much, but under the Truth in Lending Act in particular, if you advertise certain trigger terms, such as a specific payment or rate, then you have a duty to also disclose certain other key terms of the loan, such as the annual percentage rate and some other things, payments, etc. So what happened to those companies that we found violated the law? We entered into an order with them in which they had to cease the misrepresentations and agree to comply with the Truth in Lending Act and the Consumer Leasing Act going forward. There are record retention requirements. They must keep and maintain and produce records upon request for a period of 5 years going forward. They also have to file compliance reports with us upon request, in particular notifying us if they've changed their business structure or anything like that. And the prohibitions in the order are effective for 20 years. And so these are onerous requirements. Second type of case that I said we were going to talk about was regarding the failure to safeguard consumer data. So in mid-2012, the FTC obtained a consent order, which is basically a settlement, against a buy here, pay here car dealer that failed to take appropriate steps to safeguard consumer-sensitive data. So that's names, addresses, social security numbers, dates of birth, driver's license numbers. And as a result of that, about 95,000 consumers had their sensitive information published on a peer-to-peer network. So that case is the matter of Franklin's Budget Car Sales Inc. And again, you can find information about this case on our website. I can tell you that we take the protection of consumer information, again, very, very seriously. In fact, at the Federal Trade Commission, we have an entire division of, I believe, 30 to 35 attorneys who are dedicated to this kind of thing. It's called the Division of Privacy and Identity Protection. The complaint against this particular company alleged violations of 3 key laws. The first is the Federal Trade Commission Act, again. There was a misrepresentation that the dealer took reasonable and appropriate measures to protect data. They also violated what we call the safeguards rule at the FTC. It's the Standards for Safeguarding Customer Information rule. And that can be found at 16 CFR Part 314. We also have a rule that we call the privacy rule. It's the Privacy of Customer Financial Information rule. And they violated that by failing to provide annual privacy notices and an opt-out provision on sharing information with third parties. Again, the Franklin defendants agreed to a consent order, and that, again, similar in some respects to the other order I was just discussing. They were required to stop the misrepresentations regarding privacy measures. They are required to comply with the safeguards rule and the privacy rule. And they are required to now implement a comprehensive information security program to comply with the safeguards rule. And importantly, they're now going to be subject to biennial information security assessments by third parties. These last few order provisions, again, are pretty standard in most of the orders that we enter. We talked about them a minute ago. Maintaining and producing records upon request, compliance reports periodically, notifying the FTC about any changes in their business, etc. I think we're up to the third type of case. case now, which is deceptive loan modification claims. I'm not sure how relevant this is to you guys, but these are the kinds of schemes that we have seen for the last few years, unfortunately, in the housing and mortgage areas. These are companies that go in and claim that they can help you avoid foreclosure or get your loan modified to make it more palatable for you. In fact, it was such a big problem in the housing context that we instituted what we call the MARS rule, which is the Mortgage Assistance Relief Services rule. And in particular, we banned what are called advance fees. So these companies were promising the world to troubled homeowners and forcing them to pay upfront fees for their services, $750 a month, $1,000 a month, and then not delivering on those promises. And so we banned in the mortgage field these upfront fees. In early 2000, late 2012 and early 2013, we obtained orders against two companies that were taking some of these concepts and trying to apply them to vehicle loans. We saw this as an emerging scheme in the market and really wanted to get out in front of it, correct unlawful behavior before too many consumers got harmed. So we brought these two cases that you see up there where we allege violations of the FTC Act's prohibition on deceptive and unfair practices. The orders ban the defendants from providing any type of debt relief service going forward. They prohibit them from making misreps about any other product or service they market, and they require them to support claims with competent and reliable scientific evidence. So, in particular, the first piece of relief there, the ban, is one of our more drastic remedies that we use at the FTC. We try not to use that lightly. We put these people out of this business altogether. Moving on to something that I think may be a little bit more relevant to you guys is deceptive cost, discount, and rebate claims in advertising. And there are two cases that we brought this September that are most relevant here and instructive, and they are the matter of Timonium Chrysler and Gantley Ford West. In Timonium Chrysler, the dealer was touting specific internet prices and dealer discounts, but was failing to disclose that consumers would need to qualify for a whole series of smaller rebates that were not really generally available to most consumers. They weren't going to qualify for these things. So it was, if they were advertising, $5,000 off the price, there was, one or two people in the whole universe that were going to qualify for all the little programs that were going to get that full $5,000 off. So there we allege violations of the FTC Act. In Gantley Ford West, it's a little different variation. They were advertising discounts on vehicle prices there, but they weren't disclosing that the discounts were only available on the most expensive models of the advertised vehicles, sort of the top of the line of whatever vehicle it was that was being advertised. And again, we allege violations of the FTC Act. The consent agreements are somewhat similar there. They bar the dealers from advertising prices or discounts unless accompanied by clear disclosures of any required qualifications or restrictions. They prohibit misrepresentations about the existence or amount of any discount, rebate, bonus, incentive, or price, among other things. At the end of this presentation, I'm going to talk a little bit about some of the guidance that the FTC has put out about advertising, in particular on the internet. We call it the .com disclosure guide, and I think some of those concepts will be helpful for you in understanding how you can advertise things like discounts and comply with the law at the same time. The next sort of variety of case that we brought at the FTC is what we call deceptive motor vehicle sales assistance claims, and that's the Matthew Lowen case. This one I think is a little bit unique in that it was an individual who was telling U.S. consumers that he could help put them in contact with a buyer for their car, when in reality all he was doing was posting the ads on his website occasionally. The order there bans him from engaging in any telemarketing or payment processing, prohibits him from misrepresenting material facts, etc. I hope you're starting to see a pattern in how our orders are structured. So let's talk a little bit about the used car rule. The used car rule was issued by the FTC in 1984 and was also recently amended. It is intended primarily to prevent oral misrepresentations and omissions of material facts concerning warranty coverage. It requires various disclosures through a window sticker that, in common parlance, as I understand, is called a buyer's guide. Since it was enacted, the FTC has brought more than 80 actions to enforce this rule, and because it is a rule that we promulgated, we have the authority to seek civil money penalties against people who violate this rule. And so far we've collected over $1 million in civil penalties on these cases. More recently, our Dallas regional office conducted a series of inspections of used car dealers in the Arkansas area and ended up issuing warning letters to 11 dealers for failing to properly display the buyer's guide clearly and conspicuously. Another important feature of some of our enforcement work at the FTC is the holder in due course rule. We call it the holder rule for short. And that's a rule that says that a subsequent holder of a consumer debt contract is subject to the consumer's claims and defenses against that original seller. So you enter into a contract with a consumer, and for whatever reason you assign that contract to somebody else or you sell it to somebody else. It basically holds that the consumer's defenses that he would have had against you as the original contracting party are still just as valid against the person that you sell the contract to. What we found was that there were a couple of courts that had held that consumers can only get affirmative recovery, like getting their money back, from the holder of the contract if the breach warranted rescission or the goods were worthless. And so we issued an advisory opinion in May of 2012 clarifying that the plain language of the rule means a consumer can get affirmative recovery even if complete rescission is not warranted. So what I'd like to do now is just kind of go through a quick example of what exactly that means. I realize we're getting a little bit late in the day and try to shed more light in the darkness here for you. So here's a good example. There's a $10,000 auto finance note, and so far the consumer has paid $8,000 on that note. At that point, he discovers a defect in the car, which would entitle him to $3,000 for the dealer misrepresentation regarding the vehicle's condition. Under some of those court rulings, the consumer could assert the defect as a defense to the $2,000 balance, but he would basically be screwed out of that last $1,000 because it did not warrant rescission. The advisory opinion just clarified that the consumer should be entitled to all $3,000 there. So now let's transition a little bit and talk about, what are the FTC's priorities going to be going forward? And I think what you see here is that we're just going to continue along the same paths that we've been going down in the last year or two. So we will be looking heavily at misrepresentations in advertising. So think again of those negative equity cases, the discount and rebate cases that I talked about, like Hanley Ford and Timonian Chrysler. This is a big priority for the FTC. I work on it a little bit with mortgage advertising, making sure that we're not luring consumers into negotiations under false pretenses, basically. Always the FTC's priority will include making sure that consumer data is adequately protected and safeguarded. You know, as this economy continues to evolve, we are collecting a lot of consumer information in each of these transactions, and there are grave consequences for consumers if that information falls into the wrong hands. And so we are going to continue to make sure that people who are collecting this consumer information take all necessary precautions to ensure that it doesn't fall into the wrong hands. Any fraudulent practice that affects consumers buying, financing, or leasing cars will always draw our attention. So again, that would be something akin to the auto loan mod cases. And then lastly, we want to make sure that online and mobile advertising is also conducted in a lawful manner. And so here's where I want to talk a little bit about our .com disclosure rights. I encourage everyone here who's advertising, particularly on the internet, I'm fairly certain almost all of you are, to review the FTC's .com disclosures guide, how to make effective disclosures in digital advertising. We issued it in March of 2013. I've got the link for the website where it can be found up there for you. I'll leave it up there for just a second. And I'm happy to make this presentation available to everyone if that makes it easier so people aren't scrambling to write things down. Some of the guidance there is really, these are principles that the FTC has been applying in regular print advertising and television advertising for many, many years. But, you know, sometimes some of these principles get lost as we try to translate that advertising onto the internet. And I think they should be mostly common sense if you're not trying to mislead your consumer. So the big principle is here is that if you're making disclosures about a big picture claim that you're making, you need to make those disclosures clearly and conspicuously. So what does that mean? It means you should mind your 3 Ps: proximity, placement, and prominence. If you're making a disclosure or a disclaimer about a big claim that you're making, you know, that certain restrictions apply or something like that, you need to be making that disclaimer in close proximity to the claim that it modifies. It needs to be placed and prominent enough so that the consumer sees it in, you know, the same place that he sees the big claim. The bottom line here, again, I think is just common sense. It's going to be whether the information about the disclaimer is actually communicated to and understood by consumers. So you can't say, get $5,000 off a Ford F-150 on your main internet landing page, and the consumer has to click through 6 other pages and links to get to the disclaimer that says you have to be a military veteran over age 80 who served in World War II on Normandy.
I have $6,000.
Again, just incorporate the relevant limitations and qualifying information into your ad claim, and rather than using a separate disclosure. That's going to be your safest bet. And don't ignore technical limitations in terms of how the website works. We have a lot of great resources on our website. In fact, we have a specific business page where we have a lot of business education materials. I know that one of the attorneys in our business education unit runs a blog and has a number of postings about the used car rule that could be very helpful.